done for some time. Last Thursday, President Biden signed the Ending Forced Arbitration of Sexual Assault and Sexual Harassment Act, a bipartisan bill to stop corporations from denying their workers the choice to sue perpetrators of sexual assault and harassment in the workplace. Until now, employers could force victims of sexual assault to resolve matters through so-called arbitration on the employer's terms rather than through our justice system. That was wrong. This is an important workplace reform that will make companies more accountable and will make workers safer. Mandatory arbitration, forced arbitration, is a powerful tool that big corporations use to take away people's choices and to make it easier for them to scam customers and workers and to get away with it. Forced arbitration takes away consumers' rights and gives more powers to corporations. In many financial service contracts, corporations will hide an innocent-looking clause in the fine print, language stipulating that disputes between customers and consumers must go through arbitration. Almost all of us have signed contracts with these clauses in them. We sign them without even thinking about what it means. But if we do think about it, we often still wouldn't have a choice. If we didn't sign, we're denied the loan, we're denied access to the bank account. Without even realizing it, Americans sign away their rights to hold companies accountable when they overcharge you, when they defraud you, like, as we saw in the last decade, opening up 2 accounts in your name without your knowledge. And by signing these contracts, which were required to get access to a bank account or a credit card or other kind of service, consumers often unknowingly sign away their rights to only choose what's best for them, which might be a day in court or might be arbitration or mediation. Studies have shown consumers do not understand what they're signing away in these agreements. It's not because we aren't smart enough. It's because corporations high-priced lawyers, it's what they do for a living, write up one-sided contract with pages and pages of confusing language to hide these forced arbitration clauses. It's not a fair contract, but it is a great setup for big companies. Sign on the dotted line, hand over your rights to us, or you don't get that bank account or service that you want. Corporations even write these arbitration clauses so they can handpick the arbitrator who works behind closed doors. They know what they're doing. They choose the venue, they choose the referee. Anywhere else, we just call that simply gaming the system. No wonder they keep winning these closed-door arbitrations. When you write the rules, the system works great for you. Look what happened to an Ohioan from Lake County, got trapped in a predatory business scheme by a company that claimed to help consumers like him to manage their debt. Instead, they defrauded him. He signed a contract in 2009 to enter into a debt relief program. The entire agreement was completed in 12 minutes, included a forced arbitration clause. Then for the next 6 months, the company charged him $1,500 in fees. Most of it was going to the debt relief company, not to his creditors. He was even sued by one creditor because the company failed to pay them. He ended up paying more in fees than the amount permitted by law. So he did what any of us would do. He sued. He was not alone. The company had been scamming other people too. They joined together to try to get their money back. Despite having these facts on their side, a federal district court dismissed the suit, upheld the arbitration clause in the contract, letting the company hide behind it and get off scot-free. All he wanted to do was bring this issue to light and get some kind of compensation for himself and the others who'd been scammed. But he was denied justice because the company buried this clause in the fine print of a contract that, remember I'd said, had 12 minutes to understand. His story is too common. State attorneys general brought dozens of actions against similar companies trying to hold them accountable for defrauding consumers. Take another example. Valerie Perry, whose husband Robert is a coal miner in West Virginia. He was out of work for some time. He relied on credit to get by. Citibank decided to sue him in court for the credit card debt, but Mr. Perry realized that Citibank was violating West Virginia law for its abusive debt collection practices. Citibank was happy to pursue its case in court before a judge when it wanted to get paid. But when Mr. Perry sued them back to hold the big bank accountable for breaking the law, Citibank forced the case into arbitration because they could. Went on for 10 years. 10 years went all the way to the West Virginia Supreme Court. It didn't matter much to Citibank that it took 10 years. To Mr. Perry, it mattered a whole lot. You can guess what happened. Citibank won. They pretty much almost always do. Mrs. Perry called the arbitration a nightmare that was never ending. According to an Economic Policy Institute report, when corporations take consumers to arbitration, the company wins 93% of the time. 93% of the time. When customers go to arbitration to try to get some kind of restitution from a company, they win just 9% of the time. 93% versus 9%. But no one's surprised. America knows that corporations play by their own set of rules. When corporations can win these rigged one-off individual consumer case settled behind closed doors, they're able to hide patterns of bad behavior from the public. If Wells Fargo hadn't snuck forced arbitration clauses into its contracts, maybe regulators, maybe law enforcement officials could have discovered the bank's illegal account opening practices early, saving consumers thousands of dollars in massive headaches. You remember how long it took before the Wells Fargo misbehavior, the kind word, I guess, to describe it, until we really understood it. But if you know you'll never pay a price for scamming and defrauding people, there's not much incentive to stop. Big companies should not decide on behalf of Americans how they should pursue justice. Consumers, not corporations, should be able to decide whether they want to go through the public court system, through mediation, or through arbitration. I'm not saying ban arbitration. I'm saying ban forced arbitration. That's why I introduced the Arbitration Fairness for Consumers Act last week with 21 co-sponsors in the Senate. Many sit on this committee. It bans forced arbitration clauses in consumer contracts. It gives consumers the right to decide how they want, each individual consumer wants, to pursue justice. Our witnesses today are scholars, lawyers who have represented consumers, policy advocates who have investigated the practice of forced arbitration and how it takes away consumer rights. I look forward to this conversation about returning the right to decide how to pursue justice to consumers. Senator Toomey.
Thank you, Mr. Chairman. Welcome to today's witnesses. Before turning to today's topic, I do hope this committee will hold a hearing soon on sanctioning Russia for this horrific invasion of Ukraine. To throttle Putin's ability to wage war in Europe, the U.S. must bring Russia's economy to its knees. This means direct sanctions on Russia's oil and gas sector. Ending U.S. purchases is a start, but we also need the rest of the world to stop funding Putin's war machine. That probably is going to require secondary sanctions on Russian banks. Secondary sanctions would force the world to choose between doing business with Russia or with the United States. We know what people will choose. This is a very important issue that is, in fact, entirely within the jurisdiction of this committee, so I hope we will take it up soon. Now, turning to today's topic, the hearings about mandatory arbitration agreements. And these, of course, are contracts where financial institutions and consumers agree to use arbitration instead of litigation to resolve disputes. They're commonly used for products like checking accounts and credit cards. Arbitration is a fair and cost-effective process for resolving disputes outside of court, which generally leads to better outcomes for consumers than litigation does. But arbitration agreements in consumer financial services have come under attack in recent years. In 2017, the CFPB issued a rule that would have banned these agreements from consumer financial products. However, Congress overturned this rule under the Congressional Review Act. Since then, a number of my colleagues have introduced bills that would undo Congress's sensible decision. These misguided efforts would harm consumers, undermine the freedom of contract, and give away millions of dollars to trial lawyers. If these efforts are successful, aggrieved consumers would receive less money less quickly. Protecting consumers doesn't require the government to stop adults from entering into agreements and undermine their freedom of contract. Nor does it require the government to micromanage the terms of the contracts. That's not protection, that's paternalism. It treats adults as incapable of making their own decisions without interference from the government. Consumers who don't want to sign mandatory arbitration agreements have other options. According to data collected by the CFPB itself, in 2015, 84% of credit card issuers and 92% of banks offering checking accounts do not use mandatory arbitration agreements in their contracts for those products. So any consumer in America who prefers to settle a dispute in litigation rather than arbitration has many opportunities to select a financial product that allows for that. Consumers do have a choice. Of course, in reality, most consumers don't make decisions based on whether their contract has an arbitration agreement. They don't need to. As multiple studies have shown, consumers generally do better in arbitration than they do in court. According to one recent study, consumers prevail on the merits 14% more often in arbitration than in court. The CFPB data showed that the majority of consumers who go to arbitration have higher rates of securing settlements or awards compared to consumers who sue as individual claimants in federal courts. Moreover, the average recovery per consumer for class action settlements was $32, while a consumer who prevailed in arbitration was awarded an average of $5,389. What's more, arbitration is more efficient and cost-effective at resolving disputes than litigation. For example, consumers don't need to pay expensive fees to lawyers to represent them in arbitration. In fact, consumers who represented themselves won on the merits in arbitration more often than those who hired lawyers to represent them. And disputes are resolved much more quickly in arbitration than they are in court. By contrast, lawsuits can be very costly, especially class action lawsuits. That's why restricting arbitration agreements would actually likely drive up the cost of financial services, which increases prices for consumers who have already been harmed by 40-year high inflation. It would also deprive consumers of the ability to access arbitration. For instance, according to the Independent Community Bankers Association, it would not be economical for community banks to continue to subsidize arbitration for customers if they're forced to carry the high cost from increased class action lawsuits. Trial lawyers sometimes claim that class action litigation is necessary to punish or deter wrongdoing. But ultimately, the most powerful incentive for financial institutions to take good care of their customers is that if they don't, someone else will. The market for consumer financial products is extremely competitive. And when they don't, financial services providers are already subject to stringent scrutiny by regulators with the potential for incurring massive financial penalties for wrongdoing. In the end, it's not consumers who benefit from banning arbitration agreements. It's trial lawyers. As I mentioned, each consumer's average recovery was just $32 in class action settlements. By contrast, trial lawyers average more than $1 million in attorney's fees per settlement. That's not consumer protection, it's lawyer protection. And liberal advocacy groups get a windfall too. Some class action settlements require payment to a nonprofit instead of consumers, even though the nonprofit was in no way harmed and probably has never even been a customer of the financial institution. In fact, two of the witnesses advocating against arbitration agreements today are from groups that actively solicit these awards. Hardly disinterested advocates. Restricting arbitration would be little more than a government-sponsored bonanza for trial lawyers and certain liberal advocacy groups at the expense of consumers seeking a fast and fair resolution of their disputes. Arbitration leads to better consumer outcomes and lower costs. Nothing about arbitration agreements merits the government stepping in to restrict the freedom of contract and to micromanage consumer decisions. Thank you, Mr. Chairman.
Thank you, Senator Toomey. I'll introduce the five witnesses today. Thank you for joining us. Paul Bland's Executive Director of Public Justice. He oversees its advocacy and litigation of consumer, environmental, and civil rights cases. He's been counsel in cases with injunctive or cash relief of more than $1 billion for consumers. Mr. Bland, welcome. Remington Gray's counsel for civil justice and consumer rights of Public Citizen, where he works in a portfolio that includes protecting consumers, promoting a fair and accessible justice system, and ensuring racial equity in society. He previously served as an attorney at the Human Rights Campaign in the White House Office of Science and Technology Policy. Mr. Gregg, welcome. Professor Miriam Gillis is Paul Verkol Research Chair and Professor of Law at Cardozo School of Law. She's a scholar on class actions and aggregate litigation. She's written extensively on forced arbitration clauses in the nation's top law reviews, which have been cited in numerous judicial decisions. Welcome, Professor Gillis. Stephen Lahotsky is a founder of the law firm Lahotsky Keller and is testifying on behalf of the U.S. Chamber of Commerce. He's previously been chief litigation counsel for the U.S. Chamber, a litigator in practice, and advisor attorney at the OLC at the Department of Justice. Mr. Lahotsky, welcome. Professor Todd Zawicki is the George Mason University Foundation Professor of Law at the Scalia School of Law, served as a senior fellow at Cato. He served as chair of the CFPB Task Force on Federal Consumer Financial Law in 2020. Written on consumer financial services, been published in leading law reviews and economic journals. Professor Zawicki, good to have you back. Please, Mr. Bland, begin and work your way that way. Just order of introduction. Thank you.
Thank you so much for inviting me, Mr. Chairman, and thank you, Senator Toomey, for your remarks. When the Congress takes a law seriously, they think there's a real problem. They know how to make sure that the laws that they pass will actually matter. And what they do is they ban forced arbitration. So, for example, in the second Iraq War, it became very clear that payday lenders were particularly targeting members of the military. And there was a study within the Defense Department that discovered that there were tons of soldiers who were unable to pay the payday lenders back. And we had more than 1,000 soldiers who were ready to be sent to Iraq who couldn't be sent because their security clearance has been ranked. So the Congress passed the Military Lending Act. They said you can never have a high-interest loan for a member of the armed services or their family, never over 36%. But how are they going to make sure that mattered? What they did was they banned forced arbitration for all Military Lending Act cases. In fact, they made it a misdemeanor. So when you hear witnesses come up and say, oh, well, forced arbitration is actually really good for consumers, if that's true, why was it a misdemeanor? Why is it actually literally a crime to have Military Lending Act cases forced into arbitration? Similarly, in the 2008 financial crisis, it became clear that fraud on the mortgage market was a huge driver of the financial crisis. More than 2 million people had foreclosures on their homes. The stock market crashed and dropped up to 50% within the first year. The economy was tanked, and one of the biggest drivers was fraud on the mortgage market. So in the Dodd-Frank Act, what did the Congress do? One of the first things they did in Dodd-Frank was they banned forced arbitration clauses for mortgage agreements. Now, there wasn't the political will to do that for payday lenders and credit cards and other big bank products, but they did it for mortgages because they knew it was really important to get a handle on mortgage fraud. They took it seriously. Last week, the Congress passed the law that bans forced arbitration for sexual assault and sexual harassment cases. In the wake of Me Too, there was a bipartisan understanding that sexual assault and sexual harassment in the workplace was a serious problem. Something needed to be done about it. So what did they do? They banned you all banned forced arbitration for these types of claims. It was understood that if you took this problem seriously, if it mattered, if you really wanted to change the world, you couldn't let companies continue to use forced arbitration to give themselves the opportunity to break the law and get away with it. So what your bill does, Mr. Chairman, the Arbitration Fairness for Consumer Acts, is it takes the rest of consumer law seriously for financial services. So right now, you have a lot of people who are suffering identity theft throughout the United States. This has happened to millions of people. And frequently what will happen is that lenders will continue to leave these things on people's credit reports in ways that devastate their credit records, make it much harder to borrow money for a car or whatever else down the road. So the Fair Credit Reporting Act has strong rules about this. In my testimony, I gave several examples of consumers who were victims of identity theft, who were being hit on their credit report for a bunch of false claims, but then when they tried to challenge the lenders and say, hey, you need to remove this from my credit record, it's not me, here's a police affidavit, I didn't do this, the creditors used the forced arbitration clause to wipe those cases away. Just last week, the state of New Mexico adopted a ban on high-interest loans. So it's very similar to the Military Lending Act. No high-interest loans over 36%. But they can't do anything about forced arbitration because the U.S. Supreme Court cases that under the Federal Arbitration Act keep preempting state laws that protect consumers against forced arbitration. So New Mexico passing this law against usurious loans is probably going to have no impact whatsoever. I speak to this from knowledge. I handled several cases in North Carolina. And in North Carolina was one of the states in which payday lending was illegal. And the Attorney General actually wrote the payday lenders in North Carolina and said, hey, you can't do this in this state. They all just continued to operate because they had forced arbitration clauses. So before the Supreme Court's decision in 2011 in the Concepcion case, which made it really easy for forced arbitration clauses to be enforced no matter how unfair they were, it used to be the courts would look at whether arbitration clauses were unfair. So in North Carolina, we had this case in a rural court. And this judge said, okay, I can handle these cases in groups. So we had the first 3 cases, we went forward, we beat the arbitration clause. We returned to people who had been victimized by payday lenders $45 million, checks sent out to them. We got all the illegal debts that were against them wiped away. We fixed their credit records. Then the Supreme Court decides the Concepcion case. So 2 cases remaining. Everyone in those cases got nothing. So this stuff like, oh, people can go to arbitration. Arbitration is really good for consumers and so forth. It's a myth. It's a fantasy. The people in those cases got nothing. Chairman, when you talked about the statistics showing why that consumers do so much worse in arbitration, that's not by accident. And part of what's happened, I've seen this in my own cases several times where I've had cases in arbitration. When you get your list of arbitrators, the American Arbitration Association, most of the people on that list are industry defense lawyers. So you think about the difference between a jury of your peers and having a bunch of industry defense lawyers. That's the reason, and I've seen this again and again on the strike sheets. That's the reason why it comes out the way it does. Thanks so much for holding this hearing, and thank you for your leadership.
Thank you, Mr. Bland. Mr. Gregg.
Morning, Chairman Brown, Ranking Member Toomey. Thank you for inviting me to testify. Forced arbitration clauses abolish a consumer's fundamental rights and remedies, no matter how widespread or egregious the misconduct may be, and deprives people of the choice to decide how to hold those who are wronged accountable. A 2015 study showed that most consumers did not know that they were subject to forced arbitration clauses, and that even when they did, consumers still assumed that they were protected by the safeguards of the judicial system. One of the most consequential decisions impacting arbitration governing consumers is Concepcion, as Mr. Bland said. There, the court held that corporations could use arbitration provisions in consumer and employment contracts to ban class actions, and that state contract laws preempted to the extent that it deems class action bans unconscionable. This holding cannot be overstated because it has given companies even greater license to slip these take-it-or-leave-it clauses into all types of contracts with impunity. The text and legislative history of the Federal Arbitration Act clearly shows that the court's holding in Concepcion and its other modern-day arbitration jurisprudence does not reflect congressional intent. The law was meant to be limited in scope to arbitration agreements between parties of roughly equal bargaining power and to be procedural in nature. The rejection of the more limited view of the FAA, originally taken by Chief Justice Rehnquist, Justice O'Connor, and Justice Scalia, and still adhered to by Justice Thomas, has given corporations near free rein to use these clauses in every aspect of our lives, clearly not intended by the 1925 Congress. The implications have been immense. Because arbitrators are not required to publicize their decisions, consumers, workers, and small businesses are now subject to decisions on issues as vast as workplace discrimination, unfair and deceptive business practices, and antitrust violations without a requirement that the arbitrator publish a decision, much less explain his or her reasoning. And if the consumer, worker, or small business loses in arbitration, and it is overwhelmingly likely that they will, the odds are quite high that they will be barred from appealing because an arbitrator's decision is given limited judicial review. Forced arbitration clauses are now included in all manner of consumer contracts. The Center for Progressive Reform found that forced arbitration is found in 44% of checking account contracts, 53% of credit card contracts, 83% of prepaid credit card contracts, and 98% of tuition agreements at for-profit colleges, and 99% of payday loan agreements. Public Citizen highlights the ubiquity of forced arbitration in all sectors of the economy and its forced arbitration wall of shame, a list that seemingly only increases. Consumers, not the wrongdoers accountable for cheating or defrauding, should be able to choose how to hold bad actors accountable. And here are a few reasons why. Stopping consumers from banding together has significant implications for those wronged. Many consumers have low-dollar claims, and therefore it is incredibly impractical to bring an individual claim in arbitration, and often doesn't happen. According to the CFPB study on forced arbitration between 2008 and 2012, 422 consumer financial class action settlements garnered more than $2 billion in relief for consumers and $644 million in in-kind relief. Third, the outrageous loss rate that consumers face can be traced in part to the so-called repeat player problem, in which companies who frequently use the same arbitrators receive more favorable outcomes, and the overwhelming lack of gender, racial, and socioeconomic diversity of arbitrators. Public Citizen supports the Arbitration Fairness for Consumers Act because it would restore consumers' choice on how to hold wrongdoers accountable for systemic wrongdoing regarding financial services and products. And in doing so, it would increase accountability and transparency throughout the consumer financial industry. According to a national survey, 84% of the public supports federal legislation that ends the practice of forced arbitration. Republicans support the legislation more than Democrats. Congress recently passed the Ending Forced Arbitration of Sexual Assault and Sexual Harassment Act, the bipartisan law garnering 113 House Republicans and a voice vote in the U.S. Senate empowers survivors of sexual assault and sexual harassment by allowing them to file a case in court rather than be forced into arbitration. It is clear, as Mr. Bland also said, that from this event, Congress can come together to protect individuals from wrongdoing. It should do so again now. Until Congress does so, however, forced arbitration will continue to hamstring consumers. Thank you for the opportunity to testify, and I look forward to your questions.
Thank you, Mr. Wright. Professor Zawitsky.
Thank you, Mr. Chairman Brown, Senator Toomey. Thanks for holding this hearing. I've been working on consumer finance issues for about 25 years now. Also served at the FTC and at the CFPB as the chair of the task force. And one thing I've come to appreciate is that consumers are not idiots. Consumers are not stupid. When consumers shop for products and services, they focus on the attributes of those services and products that matter to them, and that in a free economy with adults making decisions, we should second guess their decisions when they enter into contracts, only if we have a very good reason to do so, perhaps because there are antitrust or lack of competition, or that consumers clearly do not understand what they are doing and it ends up harming them. In this question that we're talking about today, it's fairly clear that this is not something that most consumers care very much about. And more to the point, it's not really clear that they should. Which is that we have a very competitive market here. As Senator Toomey mentioned in his opening remarks, it's very easy for consumers to find financial products in most markets that will allow them to bring lawsuits if that's what they really care about, if they care about that more than their interest rate or their rewards or whatever the case may be. My guess is there's probably a lot of people in this room right now have credit cards and bank accounts that contain mandatory arbitration clauses. Why? Because they prefer some of the other attributes that those products give them as part of the overall mix of prices and services that go along with those products. And what we see when we look at this is that consumers have a lot of redress in a variety of different ways, which is when they are asked what they would do if they felt like they were subject to an inaccurate or unfair fee. Most people simply say they would complain. And if they did not get what they wanted, they would switch cards. And when you look at as part of my research with Professor Jason Johnston, we got a hold of some records from a regional bank in Texas, and they found that over 2/3 of the time when consumers complain, they get a full refund. And many of us understand that if we feel like we're mistreated, we don't call a lawyer. In fact, less than 1% of people in the CFPB survey said they would call a lawyer as one of the things that they would do in that situation. We complain, and usually banks are responsive. Why? Because they want to keep customer goodwill. We also know that if you work your way through the internal dispute resolution, that you do have the right to arbitrate at the end. And it's clear, and we can argue over the details of it, but what we know about arbitration is that arbitration isn't the Wild West, that there's been a substantial body of case law built up by judges that ensure that arbitration is a fair and effective process for consumers. There are often provisions that provide, for example, minimum recovery for consumers who do not who prevail in arbitration. And so it's only after all that process might be exhausted that consumers might be considering litigation. And what we know about litigation is that individual litigation is a disaster. Consumers are not going to protect by individual litigation. I think as Mr. Bland notes in his testimony, most of the time an individual complaint, most lawyers aren't going to take those cases because it's not affordable to them. Unlike arbitration, where consumers can proceed on their own, if you want to bring a lawsuit in court, you have to hire a lawyer. Otherwise, you're in trouble. So really the only question then becomes whether or not you can bring a class action case. And we all know what our experiences are with class action. The data tell us what we know, which is an overwhelming number of class action cases provide little or no relief to consumers and provide a bucket full of money to class action lawyers. And so when you look at what consumers have chosen, why consumers have chosen it, to think that the consumers are systematically making a mistake or systematically shooting themselves in the foot simply because they choose via contract to have their disputes resolved through arbitration is a fail-safe. If their efforts to have their complaints resolved is not otherwise resolved to their satisfaction, I think is a perfectly reasonable choice for most people. It's a choice I've made, I think, probably with all of my financial products. And I don't feel in any way that I've been cheated by the fact that if I'm dissatisfied, I would have to arbitrate rather than being able to call up some class action lawyer and maybe somewhere in a couple of years getting a few bucks and a coupon. Thanks.
Thank you, Professor Zwitzky. Mr. Lutsky, welcome.
Thank you, Chairman Brown, Ranking Member Toomey, members of the committee. Thank you for the opportunity to appear before you today to present the views of the Chamber of Commerce of the United States of America. The U.S. Chamber strongly supports arbitration because it is fair, less complicated, and lower-cost alternative to our overburdened court system. The arbitration process uses impartial decision-makers and is subject to strict fairness rules. The American Arbitration Association rules require that arbitrators must be neutral, that limit the fees that consumers must pay to $200, which is less than the filing fee in federal court, empower the arbitrator to order any necessary discovery, and also require that damages, including punitive damages and attorney's fees, be available to the same extent as in court. And the courts provide another layer of oversight with respect to the arbitration process. If an arbitration provision is unfair or unconscionable, courts can and do step in to declare those arbitration agreements unconscionable and unenforceable under generally applicable contract law. And they can and do invalidate arbitration agreements that impose unfair procedures. Empirical studies show that consumers do well or better in arbitration as in litigation. They prevail on their claims at the same rate or more frequently, and they recover as much or more when they prevail. A study sponsored by the U.S. Chambers Institute for Legal Reform compared decisions on the merits in consumer arbitrations and consumer lawsuits in court. It found that consumer plaintiffs win more frequently in arbitration, 44% compared to 30%. Consumer plaintiffs also receive higher monetary awards in arbitration than in court. The median award to a consumer in arbitration was $20,019 compared to only $6,565 in court. The mean award in arbitration was $68,198 compared to $57,285 in litigation. Arbitration is much simpler and less costly than court litigation in terms of money, time, and effort required by the dispute resolution process. All parties benefit from the reduced expense and complexity. As a result, consumers can resolve their claims quicker in arbitration than in litigation, and most importantly, they can seek redress for claims that could not practically be brought in court. The empirical study of consumer arbitrations in court cases I described a minute ago found that arbitrations in which the consumer plaintiff prevailed averaged only 299 days in length, whereas cases in court required an average of 429 days. Notwithstanding these benefits of arbitration, the Consumer Financial Protection Bureau in July 2017 issued a rule that would have effectively eliminated the use of all arbitration agreements in disputes between consumers and providers of financial products and services, leaving consumers wholly dependent on class action lawyers' willingness to take on and effectively litigate their disputes, even though most consumer complaints are individualized and cannot actually be litigated as class actions. The Bureau's rule would have harmed consumers and businesses and benefited only class action lawyers. The Bureau purported to permit some continued use of arbitration by targeting only arbitration agreements that specified individualized dispute resolution and prohibited class actions. But facing the uncertainty of high litigation costs associated with class action suits, businesses would no longer offer an alternative arbitration mechanism for which businesses would shoulder the lion's share, that is to say, almost all of the costs. Rather than paying the costs associated with two dispute resolution systems, arbitration and judicial, they would have dropped arbitration because the Bureau's rule would have made it impossible to avoid court-related litigation costs. Effectively eliminating bilateral pre-dispute arbitration agreements would impose significant costs on providers of consumer financial products and services, ultimately to the detriment of all consumers and the public. I look forward to answering your questions and to today's discussion.
Thank you, Mr. Walensky. Professor Gillis, welcome.
Thank you for having me. Chairman Brown, Ranking Member Toomey, I would say distinguished members of the committee, but there aren't any yet here. There are terrible things going on in the world today, so I'm especially grateful that you're taking the time to talk to us today about the harmful effects of forced arbitration in consumer financial contracts. Because as we sit here, I think you're right, Professor Zwicky, every single person in this room and probably every single person in this country is subject to a forced arbitration clause in some aspect of their consumer life. You want to use a credit card, open a checking account, use a cell phone, get a loan, send your kid to camp, or put your mother in a nursing home. You are signing away your rights to all sorts of things. The right to seek redress for violation of privacy laws, product liability, data breaches, fraud, and more. These provisions are everywhere today, and they're buried in the fine print of take it or leave it contracts that demand that all disputes be resolved in private one-on-one arbitrations. But at the outset, just given all that's been said here, I'd like to spend a moment to quickly dispense with the false narrative that arbitration is better, faster, and cheaper for consumers. I think this is a story that's been peddled by the Chamber and rehearsed by Republican witnesses, and I think it's absolutely wrong because every reputable study out there, every single one, and reputable, right? Not studies that the Chamber gives us, but reputable studies by neutrals have put a lie to this point by showing incontrovertibly that given the tens of millions of consumers that engage in transactions every year, a tiny, tiny, tiny percent decide to arbitrate their claims. So how do you explain that? I mean, if it's as awesome as these guys are saying, right, why isn't everybody doing it? Well, it could be, and maybe some people would argue people aren't doing it because companies aren't violating our consumer laws. They aren't being negligent with our personal information. They're not charging illegal fees or engaging in illegal activities. The companies are being totally awesome, and there's no need to bring arbitrations because we're never getting injured. But that's not the case. That's not true. We'd like it to be that, but that's not true. Instead, the reason so few consumers are bringing arbitrations is because they have no idea they've signed away their rights to a judge and jury to a fair and open process. They've signed away their rights to band together with other injured consumers to level the playing field. They have no idea. So when Professor Zwicky talks about choice, this is like two Americas. There's no choice, right? If I want that Apple iPhone, I'm going to click on terms and conditions that somehow way down there on the screen contain a forced arbitration clause. I'm not choosing necessarily. And if I look around the market, guess what, Professor Zwicky? Every single cell phone requires me to do that. Where is the choice? Where is the choice here? I think this is illusory. The one thing I will agree with Professor Zwicky about is that American consumers are smart. They're savvy. Because once they see this unfair system that they've been forced into, that they've been given no choice but to enter into, they get it. They get what's going on, right? If the company is picking the arbitration provider, if the company is writing the rules, if the company can change the rules whenever it wants, that's just not a system anybody wants to be part of. That's stacked against you from the get-go, and consumers see this. And I think that's the reason that we see so few arbitrations and why so many of the numbers that we've just heard are completely wrong and false. Consumers don't enter in this process because it's not a process they chose and they know they can't win. And in my view, I think that's exactly what companies are banking on. The companies that make up the Chamber of Commerce membership are banking on this, right? This is why these people are here, because they want to hold on to this immunity that they have been able to draft into their own contracts. They're here because companies know that consumers will not arbitrate, and therefore they will not be held legally liable, which means they can basically do whatever they want without any public accountability. And that's just not really the way our civil justice system is supposed to work, right? Companies shouldn't be able to get off scot-free without any accountability. And this harm, I want to say to you, is not just a harm to consumers. I'm a law professor. I'm concerned about the fabric of the law, and forced arbitration is hurting the fabric of the law, and it renders what you do in this body, no offense, pretty useless, right? You're here to enact laws, consumer laws, employment laws, antitrust laws that are supposed to protect the American people. But in order for those laws to be effective, violations have to be detected, and forced arbitration suppresses that. And it makes what you do less viable. I fear we're at a tipping point where legislation, like the bill that Chairman Brown posted yesterday, is necessary to preserve the rights of the American consumers, to restore their faith in their economy, and frankly, to restore their faith in the law, to protect them. And I'll just close with this on what I hope is the run-up to a historical appointment to the Supreme Court. I want to close by invoking the late Justice Ruth Bader Ginsburg. In one of her last dissents before she died, in a case called Lamps Plus versus Varela, she issued a clarion call to all of you. She said, I can't do anything about this court, right? It has gone down this road on forced arbitration, and I'm in the minority. I can't change it. But you, Congress, can, right? You're here to make policy, to protect consumers against the scourges of forced arbitration. And listen, she wasn't alone. State court judges, federal court judges, state attorney generals have been pleading with Congress to act for years. And so I hope you will do so. I look forward to your questions. Thank you again.
Thank you, Professor Gillis. Start with you, Mr. Bland. Companies hide, as you've pointed out, as several of you did, and hide arbitration clauses deep in the fine print of customer agreements. A 2015 survey found that consumers don't understand arbitration agreements. Fewer than 1 in 10 who were surveyed realized that an arbitration clause would prevent them from exercising their constitutional right to go to court. Is in your mind, in your experience, is this survey correct? Are consumers aware of arbitration clauses and the fact that they're signing away that right?
The survey is clearly correct, Senator. We've represented hundreds of consumers, and I've yet to have a situation where a consumer comes in the door where they know about the arbitration clause. They nearly always find out about it when they hire a lawyer, and we dig through the fine print and tell them. And the clauses are written in ways that are unreadable. So if a payday lender is trying to communicate with consumers to get you to take out the loan, they write it at basically a 7th or 8th grade level because they know that that's what consumers need to really to have fully penetrate the market. The arbitration clauses are written at like a PhD level or worse. I handled a case in Florida where the first sentence of the arbitration clause was 256 words. And they're trying to parse this, trying to make sense of it. It was completely incomprehensible. The CFPB study actually found that even if you take the lending contract for a credit card and you put it in front of the consumer and you put a big red box and say, this is the arbitration clause, read it, 95% of the consumers who read the box can't understand what was in it. They still think they can go to court. These things are written and designed so that no one will understand them, and you're exactly right.
Thank you, Mr. Bland. Professor Gillis, arbitration, as you've pointed out, is a confidential proceeding that occurs outside the public eye, unlike a trial in open court. What that means, of course, is that third parties aren't able to see what happens in arbitration, including what the claims are and how they are resolved. You use that fact to call on us to change laws. What are the drawbacks or benefits of any of the closed-door arbitration system? And also answer it, if you would, do secret arbitration cases tend to favor big corporations by making sure that patterns of bad practices never come to light?
Thank you for the question. As Justice Brandeis said, sunlight is the best disinfectant. And I think when you have a closed-door secret hearing where nobody can really know what went on in that hearing, and arbitrators don't write written decisions, don't necessarily even have to follow the law, and face very, very, very low possibility of an appeal, I think we have to all worry about whether that system is really as fair and as neutral as its proponents say that it is. You mentioned the Wells Fargo fiasco. There have been many, but the one about bank employees opening sham accounts, it's a perfect example. The customers were aware of this back in 2013, but it took the rest of us until 2017 to figure out what was really going on, and that's because Wells Fargo used their forced arbitration clause as a shield, right, as a way of reducing the bad publicity as well as the liability.
Thank you, Professor. Mr. Gregg, forced arbitration clauses give even more power to Wall Street over working families. The rights of consumers seeking accountability, seeking justice are handed over to corporations. Are corporations, my question is this, Professor, or Mr. Gillis, are corporations forcing consumers into arbitration because they're looking out for consumers or because they look out for themselves? Should big companies be allowed to decide for consumers?
Well, they shouldn't. That's the short answer. What we're seeing essentially is why should the potential bad actor, create the rules of the road? And And so the consumer has no choice but to accept those rules of the road. We're talking a lot about choice nowadays, choice as it relates to schools, choice as it relates to whether I should take the vaccine. Why can't we have consumer choice? And the last thing I would say is that in that terms of the issue of, well, you can go someplace else. Well, as I mentioned in my statement, almost 100% of all payday lending contracts have a forced arbitration clause. Black consumers use payday lenders at 105 times the rate of other people. And they overwhelmingly don't use arbitration. They don't understand the process. And so when you talk about choice, there is absolutely no choice there. You were telling them they must use this system that they're not using. And in the end, payday lenders are not being held accountable.
Thank you, Senator Toomey.
Thank you, Mr. Chairman. So, Mr. Zawicki, I'm going to ask you to respond to this notion that consumers don't have any choice. Apparently, there's just no choice. Everybody has to sign a contract that takes away their ability to hire an expensive lawyer and go to a courtroom and instead arbitrate. Is that your view, that consumers really have no choice?
That clearly is not what the evidence indicates for virtually all financial products, whether, as you mentioned in your opening statement, there are thousands of banks, there are thousands of credit card issuers in this country, and only a relatively small percentage of them require arbitration as part of what is part of the terms and conditions for dealing with that provider.
So, just to be completely clear, if a consumer felt that this is an important criteria for them to reserve the right to go to court instead of arbitrate in the event that there's a dispute, the consumer would be able to exercise that judgment and choose the product that gives them that choice.
All the evidence I've seen suggests they have plenty of options if that's a term that they really care that much about.
We've also heard that it's only a tiny, tiny fraction of cases where consumers choose to go the arbitration route. Could that possibly have anything to do with the fact that the normal thing that people do, if they think that their bill is incorrect or they were otherwise not treated properly, the sort of normal thing is you call up the firm and say, hey, you got this wrong, you need to fix it?
And that's exactly right, Senator. And that is the fatal flaw, the complete, as I said in my statement, cloud cuckoo land of the CFPB, this absurdity that simply because there aren't a lot of arbitrations, that somehow that means the system has failed. As we found in our evidence, in the work we did, overwhelmingly when consumers complain, they get a full refund. That also suggests that maybe the consumers don't get a full refund, don't have a very good complaint. We don't know for sure. But in the world of the CFPB, the only way you could show that arbitration works and is effective is if you complain to the bank, even if you had a legitimate complaint, and the bank basically said, pound sand, you have to arbitrate. I don't see how that helps anybody to say that turning down somebody who has a complaint and not giving them a refund just to show that arbitration is an effective process, that just seems completely perverse to me.
You also indicated in your testimony that if we did have a complete prohibition against arbitration agreements, it would probably have significant second-order effects, including driving up the cost of financial products and services, which means in turn consumers would just pay more for their routine financial service. Can you elaborate on that and walk us through that dynamic?
Absolutely, which is that if you unleash class actions in this area, consumers are not likely to turn out to be the winners in the end. Which is to say that we've even got a lot of situations where these no harm class actions, where class action lawyers bring a claim, often under these federal provisions that provide for statutory minimum damages, where consumers haven't even suffered any real harm. But if you just pile on litigation without any benefits to consumers, eventually that raises costs, and those costs have to go somewhere in the system. And usually, what that means is they'll get passed on to consumers as a group. I'll also quickly say that with respect to the CFPB's analysis on that, it's completely flawed. It's not serious economics. They claim to find that a short-term suspension for a couple of years of arbitration clauses they found had no price effect. I don't know of a serious economist who would actually think that that would have a price effect for temporary adjustment like that.
And Mr. Lehotsky, could you just address the question of whether consumers are capable of understanding what's in their best interest when they choose which financial products to pursue?
I certainly agree with Mr. Zwicky, and I think maybe the entire panel, that they are. And I certainly agree with Professor Zwicky that they make choices for financial products and services based on what's in their best financial interest, and that is not retaining a class action lawyer, being part of a class action. It is buying the thing, the financial product or service or the good that they're looking for.
Thank you, Mr. Chairman.
Thanks, Senator Tewers. Senator Warren from Massachusetts says she's settled and ready. If not, we can go to somebody remote, but you're here, so go for it.
I'm never settled, but always ready. All right. Thank you, Mr. Chairman. So giant corporations and big banks put forced arbitration clauses in the fine print in their contracts. And this means that someone who gets cheated by them can't go to court. Instead, they have to go to a secret tribunal where every year millions of people who get cheated just lose out. No judge, no written opinion, no appeal. Just an order from someone who gets paid by the case and who may never get picked to arbitrate again if they rule for the consumer too many times. But there's another problem with forced arbitration. Let's say I open a checking account with Wells Fargo, and I signed a contract with no mandatory arbitration clause. Soon after, my hypothetical Wells banker cheated me out of $30, and he just took it out of my account, put it in his own. When I called, Wells said, "Yeah, that's our policy. Too bad for you." Professor Gillis, you're a nationally recognized expert on mandatory arbitration clauses, but let me ask you, I'm mad, no arbitration clause here. Would I likely find a lawyer, pay the filing fees, and go to court to recover $30?
No, it really wouldn't be worth it.
Okay, but how about if I had a mandatory arbitration clause? Professor Zwicky says that these clauses are efficient. So, Professor Gillis, would I or would most people go to the trouble of figuring out how to file an arbitration complaint, to fill out the forms, to collect the paperwork, to take off work, and to show up for an arbitration hearing for $30?
Nope, it's still not worth it.
Still not worth it. Okay, so most people are not going to follow through with a complex procedure to collect $30, arbitration clause or no. But let's say that Wells Fargo cheated half its customers. That would be about 35 million people, exactly the same way they cheated me. Professor Gillis, if Wells did not put a mandatory arbitration clause somewhere in the fine print, would there be a way for 35 million Wells customers to sue the company together, cheaply and efficiently?
Yes, it's called a class action.
That's right. Tell us a little about how class action
Well, the policy at the core of the class action device is precisely this, to aggregate claims that on their own are too small to bring individually, whether in court or in an arbitration. And to pool resources, right? To pool the consumer's resources so that they can more efficiently litigate against a common and usually more well-resourced adversary.
So the people get some redress on their $30. Mm-hmm. And what effect does it have on Wells?
Well, I mean, traditionally, hypothetically, it should deter Wells from engaging in misconduct in the future.
Okay, so now let's ask about the reverse. If Wells did put a mandatory arbitration clause somewhere in the fine print, is there a way for 35 million Wells customers who were cheated to sue the company together, cheaply and efficiently?
No. And this is exactly what we're talking about. These class-banning arbitration clauses deny consumers the ability to band together, to pool their resources, to be able to level the playing field so that they could adjudicate their claims against a company as big and well-resourced as Wells Fargo.
And what kind of impact does that have on Wells Fargo?
Well, if I'm Wells Fargo, I can basically do whatever I want, right? $30 here, $30, 35 million times over. The only thing you have to fear is detection by a public enforcer, but, public enforcers' budgets can't monitor every single transaction in the marketplace. So no deterrence.
So think about this. Because of mandatory arbitration, Wells Fargo could openly cheat 35 million customers, and except for a few people who one at a time go to arbitration, Wells would just keep the money. And in my example, that would be well over $1 billion free and clear for our hypothetical friends at Wells. Big banks, giant corporations, and groups like the Chamber of Commerce say that forced arbitration is good for consumers because it is fair and efficient. There is nothing fair and efficient about arbitration. It is a very clever way that very clever lawyers for very big corporations and very big banks dreamed up to be able to keep customers from having any effective power when those big corporations or those big banks cheat their customers. Now, it's not shocking that big corporations continue to do this. It's shocking that Congress lets this scam go on year after year after year. It is time to outlaw mandatory arbitration and to tell companies that when they cheat their customers, they may finally have to face some accountability in court. Thank you, Mr. Chairman.
Thank you, Senator Warren. The chair recognizes Senator Van Hollen remote if his camera's on. If not, Senator Smith from her office. If not, Senator Warnock from his.
I'm here, Mr. Chair, from my office. Thank you.
Senator Smith from Minnesota is recognized. Sounds like your voice.
Okay, great. Thank you so much, Mr. Chair, for this hearing, and thanks so much to our panelists as well. I want to talk first about this issue of secret outcomes in these arbitration proceedings and what impact that has. You know, as we've been discussing, consumers face significant obstacles before they can have their case heard in an arbitration proceeding. But we shouldn't forget that even if a consumer beats the odds and wins an arbitration judgment, there's often no guarantee that the company will actually change their bad behavior, because the results of those arbitration proceedings are rarely made public, and then the company may have incentives to settle the individual claim without addressing the underlying issues. And furthermore, other companies engaged in similar behavior don't even have the opportunity to evaluate whether they should change their practices or to reduce the risk of future liability. So I'd like to, this should be to, to Ms. Gillis. Could you discuss how these secretive outcomes of arbitration proceedings can help perpetuate these unfair corporate practices?
Thank you for the question, Senator. I think that the secret hearings are a problem for all the reasons that you stated, but I'd like to add one more. It's not just that these arbitrations happen in a closed vault where we don't know anything about what happened in the arbitration, and so we don't know if the company's going to change its practice or if other similarly situated companies will do the same. The reality is that very smart lawyers, as Senator Warren said, have drafted arbitration provisions that prevent an arbitrator from entering any kind of award that changes policy. The typical arbitration contract these days says that the arbitration provider can only resolve the claims of the individual, cannot resolve the claims of others who might be affected by the same wrongful behavior. So these claims are single-filed, and they're siloed, and they're secret, which is sort of the exact opposite of the way our judicial system works, right? Which is public. We have access to what's happening in a courtroom, into the facts of the case, and judges are authorized to order broader relief, not just relief to the individual, but to enjoin a company from engaging in future misconduct. All of that is missing in the arbitration regime.
Right, right. So it's as if there was if this was in court, it would be as if there was a finding in court, but it only applied to that specific case and not to any other incidences of that misbehavior. And at the same time, nobody else was allowed to even know that finding had happened. And so there's the justice isn't perpetuated; it's actually stopped by the secretiveness of these proceedings.
Yeah, exactly. So it's really hard to imagine how people on the other side can say that this is an efficient system. This is the exact opposite of an efficient system.
Right. Well, it's an efficient system if you're trying to minimize your cost,
Right.
But not an efficient system if you're trying to maximize consumer protection. Let me just follow up on one other thing. This is around issues of equity. According to the Pew Charitable Trust in Minnesota, Black Americans are twice as likely to have a payday lender near their home in comparison to the rest of the population. We've talked about this in this committee before. Minnesota, 8 out of 10 payday loans aren't repaid when they come due, which then, of course, traps borrowers in a cycle of debt that can end up costing them thousands of dollars. And on top of the predatory nature of these, the Consumer Financial Protection Bureau has found that 98.5% of payday lenders also impose arbitration on borrowers. So we know that many people get payday loans who are already in a precarious financial situation, and a lot of these folks are low income and are unlikely to be in a position to have the time or the money to fight for their rights as consumers. So let me just maybe direct this to Mr. Bland. What type of impact do you think these clauses have on on lower income borrowers, these forced arbitration provisions?
Senator, the clauses are devastating to low-income borrowers. I've represented a number of people who have been scammed by payday loans. You know, payday loans, Pew did a study in which they called payday loans essentially a failed product, by which they mean that the vast majority of consumers who undertake these think it's going to work out one way when they go in, and then it works out dramatically different. And something like 95% on average of the loans end up being rolled over. So you have a ton of people who borrow $250 and ultimately pay out $1,000, even $2,000 before they ever pay back the $250 because the way the money rolls over. And it really pushes people from being low income to being destitute. And with this, payday lenders all rely on forced arbitration clauses to wipe away state laws that would protect consumers. And they protect both deceptive practices and also just usurious practices. So it's a great point, Senator. Totally agree.
Well, thank you. I think it's another great example of how these forced arbitration provisions are. I mean, frankly, Mr. Chair, I think that they're targeted to take advantage of people who are least able to defend themselves in our economy. Thank you very much.
Thank you, Senator Smith. Senator Van Hollen of Maryland is recognized.
Thank you, Mr. Chairman. Thank all of you for your testimony here today. Mr. Bland, I want to recount a recent story that I think highlights the unfairness of denying victims of financial fraud their day in court. The story is about an 87-year-old woman. Her name is Myrtle Bratcher, and a check in the amount of $175,000 was drawn on her account. It had her signature, but other markings on this check were clearly inconsistent with her handwriting. The memo line said, quote, home renovation, and yet the check was made out to a Chinese technology company. This is a $175,000 check. It was also totally inconsistent with her prior practice. The maximum she had drawn for years on her account was $200. Her savings are totally wiped out. She's had to move out of her home. I want to credit Dan Rodricks with the Baltimore Sun, a columnist, for highlighting her case. We have written to the two banks involved, JP Morgan Chase, the branch in New York that accepted the check, and PNC Bank that cashed it, asking for them to provide relief to her. So far, we've gotten no response. I can assure you she could get a lawyer to bring this case for $175,000. How, in your view, does this case illustrate the unfairness in requiring her, because she unknowingly signed some provision in some bank contract years and years ago that required her to go through arbitration instead of getting her day in court?
Senator, it's a great point. You're my senator, so I'm really glad to see you here. Senator, if they have to go to arbitration, what's going to happen to this woman is she's going to get a list of, say, 5 arbitrators from the American Arbitration Association. And when her lawyer looks at the list, 4 or all 5 of the lawyers on the list are going to be industry-side lawyers. So instead of having to, if she's able to go to a Baltimore jury and speak to actual real life human beings who would understand this, that you get a different kind of response than if you have an arbitrator who's essentially going to be an industry defense lawyer. And so that's going to be one of the real issues that she's going to face in this. She's also going to have very limited ability to take discovery in arbitration generally. A lot of arbitration clauses include a loser pays provision, which you would never see. It's not allowed under the normal consumer protection laws. So there's a possibility that if she brings the case, she might have to pay the bank's lawyers' fees, which you would not have in the court system unless her case was totally frivolous, which it clearly isn't. But she's really looking into a pretty rigged system that's rigged against her. It's just unfair.
Right. I appreciate you raising the issue of some of these provisions requiring those who don't prevail in arbitration to pay court fees, because that obviously creates a huge disincentive, especially for somebody who's acting on her own behalf here. Professor Gillis, could you speak a little bit to how a court case can better incentivize companies to change their conduct? So, for example, if these banks were facing the prospect of a court case for overlooking what clearly was highly suspicious activity, do you think that they would take additional measures within the banks to prevent this kind of fraud from being perpetrated?
I do. And I actually think that's what our legal system believes, right? That's why we have a system of laws. It's why we have a system that allows private individuals who've been injured to bring lawsuits, because we think that once this is public, first of all, other similarly situated banks will know, gosh, this is a big deal. We should not do this. If we were thinking about it, we should stop thinking about it. It enables other citizens to better protect themselves, right? Because they know this sort of fraud is out there, so they'll be more careful. But the deterrence function of litigation, whether it's individual or class, is just as important as the compensatory function, right? Both have to work for litigation to have these effects, which I think it does.
Well, I appreciate that. I agree with you. Look, it's one thing if a corporation doing business wants and entering into a contract with another company or corporation wants to enter into a arbitration agreement between two parties sort of equal power and strength. That's fine. But I think we all know the reality. I've listened to the testimony. We know the reality. When people are asking, as you said, for an Apple phone or they're sending a credit card, they do not go and look at the stuff buried in there. And even if they did, are their choices to not participate at all? Now, I realize some people would say, well, that's just bargaining. That's just a contract. But the reality is what we're talking about is a public policy that would prevent those kind of contracts that are usually unknown to the constituent, but also of parties of totally unequal power in this case. So we're going to continue to work with these banks to make sure that Merle Bratcher gets justice in this case. As I said, she's out of her house right now, and she doesn't have the option of going into court, a case I think many people think she could win in court because of this forced arbitration agreement. Thank you, Mr. Chairman.
Thank you, Senator Van Hollen. Senator Cortez Masto from Nevada is online from her office.
Thank you, Mr. Chairman, and thank you for this important discussion. I'm going to follow up on some of the line of questioning that Senator Van Hollen just touched on. Professor Gillis, what is an adhesion contract?
An adhesion contract is a contract that's take it or leave it. There's no opportunity to negotiate the terms of the provisions, to redline, edit, add your own terms. You just have to take what they give you. As they say in my daughter's preschool, you get what you get and you don't get upset. That's just the way it works.
And how many of these financial institutions or these banks that we're talking about or others that have forced arbitration, how many of those are adhesion contracts?
I can't give you the actual number, but my guess is that nearly 100% of them are. That's the most efficient way for a bank or any financial institution to transmit a forced arbitration clause is through a standard form contract.
That's right. And usually there's a stronger negotiator over a weaker one, and the weaker one wants the service, which is the consumer who wants a service, but doesn't get to negotiate the contract. So you heard earlier Senator Toomey talking with Professor Lahosky about, well, they just can go choose some other service. Is that true? Can they go choose another service?
I mean, this is so frustrating because when 99% of credit cards or, 88% of banks use these forced arbitration provisions, and by the way, those numbers are a little bit old now. If we were to do that study today, we might be nearing 100%, because why wouldn't you use the forced arbitration clause, right? I mean, if you were general counsel to any of these companies, you would say, you know what, to limit our liability, we better stick these magic words in these contracts, because if we do that, these consumers can't sue us in court. So today, I would bet some money, I don't have much, but I would bet some money that it's almost 100% of banks and other financial institutions that impose these provisions. And if that's the case, I don't understand how Professor Zwicky or Mr. Lahosky can tell us that there's choice. Where's the choice? I mean, somebody has to explain to me, do I have to go looking for some off-brand flip phone? Do I have to buy a burner if I want to use a cell phone? Because every major cell phone provider today requires you to sign a forced arbitration clause. I think this choice is illusory, quite frankly.
And isn't it true that most of the people that really are looking to the best service for them are also those that are looking to reduce cost and maybe don't have means to pay for the biggest and brightest service or the biggest, best phone, but they got to limit their costs. And so they may be stuck with a contract based on the lower cost more so than being able to choose something else. Is that correct?
Yeah, I mean, at least along the margins, you're absolutely correct. I think for lots of goods and services that most of us purchase, cell phones, credit cards, bank accounts, I think that we are there's not a lot of choice there, and we're not making a lot of choices. But you are right that low-income groups are going to bump into the hard edges of the law more often here. They will be subject to payday loans and other abusive practices where forced arbitrations are nearly universal in a way as a means of protecting those companies from liability.
Yeah, and free choice really is giving the consumer the choice to either pursue their redress of any type of a grievance, either in the courts or through arbitration. That's free choice, correct?
Yeah, right. I think nobody here is saying let's get rid of arbitration altogether. Instead, the idea is let's not force it on people before a dispute has even arisen. Let's raise it after a dispute has arisen and let the consumer use their good common sense about what they want to do. Let them exercise the choice and decide whether they want to mediate, arbitrate, or litigate their claims.
Yeah, and that's why I find this so fascinating because, listen, as an attorney, as a young attorney in Nevada, the 8th Judicial District Court actually created a program for alternative dispute resolution. So you could either choose the court going through a civil action, or you can choose to mediate or arbitrate, and you talk to your clients and you figure out what's the best for them and working with them to pursue this. And I do agree that there are some arbitrations that are very successful and there's a need for them. I do not understand, I guess, from the perspective of some of the arguments today that this argument that it's so good for consumers that that's all they should do is arbitration. It really goes counter to what I see some of my colleagues always talking about, the freedom of choice. So it really doesn't make sense to me. The other thing I do know, and let me ask Mr. Gregg this, because the challenge I see here is that when we're trying to hold companies accountable for a pattern or practice of fraud or taking advantage of a large group of individuals, that is often the case when it comes to financial institutions. These financial institutions, if they're going to be caught in taking little pieces of fees or costs from individuals, it's going to be the collective that most attorneys will go after to hold them accountable, not one individual. Can you talk to that a little bit, if you would?
Yes, Senator, and I'll be quick. That's correct. Oftentimes, what you're finding is that people since they're not able to band together, they're not able to vindicate their rights. Sometimes the federal government, as Professor Gillis was saying, can do that. The Department of Justice, for example, has gone after Wells Fargo, for example. The CFPB has gone after Navient for excess student loan interest against service members. But we cannot rely on the government to police all the bad actors. What we see, for example, in the securities context is just that. Both Republicans and Democrats throughout the last 50 to 100 years have said the best way to police the marketplace is both the government as well as complementary policing by the private sector, by investors. And so we should have that as well for consumers. Consumers helping to police the marketplace as well.
Thank you. Thank you, Mr. Chairman.
Thank you, Senator Cortez Masto. I don't think Senator Warnock and Senator Sinema are online. Is that correct? Okay, we will wrap up our hearing. Thank you. It's important this committee continues to work on banning forced arbitration in consumer financial products. However, arbitration is also important in other financial contexts, including in security. To that end, I want to include for the record a letter from the Northern American Securities Administrator Association without objection. Thank you, Senator Toomey. Thanks to the witnesses for being here today. For senators who wish to submit questions for the hearing record, those questions are due 1 week from today, Tuesday, March 15th. To the witnesses, please submit responses to the questions for the record 45 days from the day you receive them. With that, the hearing is adjourned. Thank you.